set up.
Of course.
Get my notes and paperwork. And if I could, I'd like to reserve 5 minutes for rebuttal.
5 minutes, very good.
May it please the court, I'm Angelo Huang of the Wilson County Bar, representing the appellant, the Davids Group, in this matter. And without rehashing my entire brief verbatim, this is a case involving an injury. The appellee, Raul Martinez, was working for the Davids Group, and on December 2nd, 2022, he was going up a ladder to a platform to work on it, and the ladder slid out from underneath him, and he fell, and he suffered various injuries, fractured ribs, contusion, brain bleeding. And so, unfortunately, at the time of the accident, the appellant previously had workers' comp insurance in place, but at the time of the accident, the policy had lapsed, so there wasn't workers' comp coverage at the time of Mr. Martinez's injury. So, under the Workers' Compensation Act, Mr. Martinez had the option, if a party fails to have workers' comp insurance, then the appellant or plaintiff has the option to either sue in court or sue under the Workers' Compensation Act. And if it's found that the injured party was an employee at the time and covered under the Workers' Compensation Act, then the defenses of comparative negligence, assumption of the risk, and negligence of a fellow employee can't be raised by the employer. And so the basis of our appeal is that Mr. Martinez wasn't an employee based on three different areas that exempt him from being an employee. One is the general statute involving workers' compensation's definition of independent contractor versus employee. And there's 7 factors, and I won't go over them because I'm limited on time. But the right to control the work, right of termination, method of payment, freedom to select hire work helpers, furnishing of tools and equipment, self-scheduling of work hours, and freedom to offer services to other entities. In this case, the trial court mainly hung its hat on the fact that there was emails given by the Davids Group to another employee, Israel Martinez, another worker, giving a punch list of different items to do. Israel Martinez is Raul Martinez's brother. Raul.
And what is your position on Mr. Israel Martinez's position? Was he an employee?
In previous years, 2020, 2021, Israel Martinez was on the payroll as an employee, but in 2022, in the year that this accident happened to Raul Martinez, Israel was switched to an independent contractor status. So he was no longer, at least in terms of the Davids Group's opinion, he was no longer an employee on payroll.
Have you raised that argument on appeal, though, as part of this case? Have you argued that as part of your appeal in this case, that Israel Martinez was not an employee in this case? And
we did argue that at trial, and a lot was hashed out over Israel Martinez's role, because a lot of the facts and basis for Raul Martinez's claim to be an employee was through Israel Martinez's actions. Mr. Raul Martinez kind of rode piggyback on whatever Israel was doing. So the court, I wasn't quite clear on how much effect it had, but the court seemed to determine that the emails sent to Israel Martinez indirectly imputed to the role Raul Martinez was doing.
But you haven't in your briefing before this court sort of advanced the argument that Israel Martinez, and you haven't sort of taken on the piggybacking aspect. You've sort of gone more directly for Raul Martinez.
Yes, okay. Because really Israel Martinez's role, he had worked for the Davids Group for years prior to Raul Martinez. So his role was broader and more expansive than the job Raul Martinez was hired to do. Raul Martinez was only hired to do the interior build-out of a restaurant building that was being constructed, while Israel Martinez was a general handyman who handled other things around the farm. So Raul Martinez's job was narrower. And which brings us to the casual employee argument. And I've cited multiple cases involving casual employment. Even if Raul Martinez is deemed to be an employee, then there's still an exemption under the Workers' Comp Act for workers who aren't working in the normal course and trade of the employer's business. In this case, Raul Martinez was performing construction work, interior building work. The Davids Group isn't in the business of construction or building.
Counsel, what if the job duties are divided and some of the work, I mean, I understand both sides are seeming to take an all or nothing position on this. It's either all within ordinary scope or none of it
Yes.
within. What if it's split? And it doesn't seem the most unthinkable thing in the world here that the work on building the restaurant was outside the ordinary. I'm not saying it is, but let's assume for purposes of argument that it is. But that the maintenance work that was being done by the employee, which you say isn't the reason he was hired, but that was within the ordinary scope. What do we do if the job itself that the employee is doing is divided between some work that's ordinary and some work that's not?
Yeah, and that's the gray area where this court has to make that fine line determination as to how far is too far in terms of casual employment. There's been situations where, I forgot the name of the case, but there's a person who worked for a boiler company manufacturer, and he examined some pipes and got injured while examining pipes. So they determined that even though boiler making was the normal course of employer's business, part of his regular duties were to examine pipes around the factory, and he got injured during the course of that. So that would be considered in the normal course of the business, even though it's pipe examination versus boiler making.
Counsel, there seem to be some cases out of the 60s and 70s and continuing on in the state. I'm thinking here Black v. Corder as one, in which a business starts to, let's say, expand its enterprise. And so we have, for example, a gas station that builds a retaining wall to be able to expand its space, where if they don't use a general contractor, it becomes part of the scope of their business. Was there any general contractor used in this case? Does the record speak to that issue, or was Davis Group essentially its own general contractor for purposes of these building projects?
In the years prior, when the Davis Group constructed their buildings, they hired contractors. In this case, the framing and the foundation had already been put up for the building that they were working on, so only just the interior needed to be completed, drywall, painting, wired electricals. So in this case, that's just the limited project that Raul Martinez was to be working on. Now, he's claimed that he did some other things, but in his testimony, he originally was asked, did you do any other work other than the construction of this restaurant building? And he said no. But then later he was asked, did you also do HVAC work? And he said yes. And so it's not really clear what he's claiming the scope of his work was. He did do work on this restaurant and maybe some occasional work on other things, maybe an HVAC unit or something, but that's all that was really testified to in the trial. But mainly, there is one case that I would cite involving the casual employee situation. Two cases, actually. There's a U.S. Rubber Products versus Canon, 113 Southwest 2D 1184, that states construction work is not the usual course of an employer's business where the employer is not a contractor or builder. And that also was repeated in the case of Ainsworth versus iWash 1, LLC, 2009 Lexus 650.
But in Ainsworth, counsel, isn't the distinction that was drawn by the Tennessee Workers' Compensation Appeals Panel that a general contractor had been hired in that case? So the car wash was not really functioning as its own general. It had hired somebody.
Yes.
Whereas here, we don't have that. I mean, we have a business that's expanding its enterprise. It's going to add a restaurant, the Chuck Wagon here, and under Ainsworth, isn't that a critical distinction? That they don't have this being handled under the supervision of a general contractor.
Yes, but still, the premise is if the employer's main line of business isn't construction or building, under the U.S. Rubber Products case, then it's normally imputed that an employee who's doing construction is a casual employee because the employer's business is not normally construction or building. Now, understand.
I want to ask you about the standard of review here. In your brief, you quote the typical standard of review following a bench trial. But ordinarily, in determine whether or not someone is an employee under the Workers' Compensation Act, that would be a question of law that we would review de novo. Are you saying that because no insurance was obtained in this case, that the standard of review is somehow different?
No, I'm claiming that the trial judge didn't really look at all of the factors that were cited in determining independent contractor relationship versus employee. There's 7 factors there, and I haven't gotten to this part since I'm running out of time, the OSHA argument, there's 20 factors under the OSHA statutes that determine whether someone's an independent contractor or employee. So the court...
And so was the question of whether or not the plaintiff was an employee an open question all through trial?
That was the heart of the matter, Your Honor.
Yeah.
Yes.
And so in this trial, did it work the same way as it would be in a situation where there was workers' comp insurance? So there's a presumption in favor of someone being an employee rather than an independent contractor, and it was your burden then to show he was an independent contractor in this case. Do you agree with that?
Yes, Your Honor.
Okay. All right. Thank you. We'll hear from the appellee.
Afternoon.
Afternoon.
May it please the court, I'm Drew Salters of the National Bar, represent Raul Martinez. I have argued this issue numerous times in past litigation regarding whether or not an individual is an employee or an independent contractor. And admittedly, there are lots of cases where that's a close question.
But you would agree that's a de novo review?
That's a de novo review.
Okay.
The facts that form that decision are issues of fact that are presumed correct. Judge, in this particular case, however, we have a situation where the defendant directly hired Raul Martinez. He had the right to fire Raul Martinez. He provided tools, and he testified at trial that not only did he have the right to control the conduct of his work, that he exercised the right to control the conduct of his work. And that's the main test. But beyond that, Raul Martinez, and the facts are clear on this, had a time card. And he had to come into work every single day and punch into a time clock to keep up with his hours for the defendant to then pay him a set hourly wage based on the hours that he kept up with. He worked there for 37 weeks. He was paid 37 checks directly from the defendant. Mr. Martinez was not paid by somebody else. He was paid by the defendant. And under the Schroeder case, that ipso facto makes him an employee. So respectfully, this issue regarding whether he's an employee or an independent contractor is not close in this case, because all of the factors point to him, he is an employee.
Counsel, what's the control in this case that's beyond, I have somebody coming over to paint my house, work on walls, and I say I want the molding done this way and I want the paint to be this color, and am I controlling the work with that?
No, you're controlling the outcome of the contract. In this particular case, there were not just emails to Israel Martinez, there was direction and control. Mr. Wilfong admitted it at trial that he had the right to fire this man, and he gave him direction as to how to do his job. Not just the outcome of the contract, because there was no contract. And they're taking the position that Raul's brother Israel was an independent contractor. However, Israel didn't have a business. He didn't have a contractor's license. Raul could not have been Israel's employee because Israel didn't pay him and he didn't have a business. And Israel didn't supervise him. The defendant did. Now, when my client, let me back up for 1 second. The reason this premises is designated Greenbelt for tax purposes is because it used to be a horse farm. It was Greenbelt designated before Mr. Wilfong bought it. When he bought it, it was nothing but a horse farm and a couple of stables. After he purchased it, he went about he went about the business of transforming the property into an Airbnb lodging venue and events venue space. And he did so by constructing 13 A-frame cabins and another 16 tiny homes at the cost of $2.5 million. So he built 29 buildings on this property. And the way that he did that was that he would hire contractors, there's proof in the record of this, he would hire a contractor to lay the foundation and to build the bones of those buildings. But then he had his own employees, Raul was one of them, that were carpenters and framers that would come do the finish work. So that's how he operated that business.
There was no general contractor at the time here, though, in this case. There was...
No, sir. No general contractor. And so
But someone else had done the footers and the framing, initial framing work for this place.
that's right.
Okay.
And my client was finishing it out as an employee, working 8 to 10 hours a day, 6 days a week, getting paid an hourly wage, punching a time clock, and getting direction from Mr. Wilfong. So he's an employee. Now, what kind of business he was, that is a question of fact that was determined by the trial court and is presumed correct. My adversary complains that the trial court found that Mr. Wilfong was transforming this property through converting it through construction to an Airbnb, lodging and events business. Well, that language, it comes from his own website. Mr. Wilfong, on his website for Starstruck Farm, says that Mr. Wilfong is a legendary businessman who has gone about transforming the farm into an Airbnb wedding-style venue.
But he's not in the construction business, is he, counsel? And the business here, entertainment space, and having folks stay in these cabins, and now there's going to be a restaurant. I mean, that's not the construction business.
Well, I think the answer to that question is my client was injured while performing construction at the direction of the defendant. Now, is he in the construction business? I would say that he is. He built 29 buildings on that property. He built a restaurant on that property for the lodging guests to have an on-site eatery. That was the purpose for expanding this business. You can't have an Airbnb lodging business if you don't have any place to lodge. And he built 29 lodgings. And you can't entertain your guests and feed them if you don't have an eatery. My client was hired to finish out work on a restaurant. So, Judge, this in the fact finding that the court did was correct. Now, when my client got hurt, Mr. Wilfong picked up the phone, called his insurance carrier, believing that he had comp insurance. And in that phone call, and we have this in writing in an email, he tells his insurer, I want this claim covered. I want you to cover this claim. Don't deny this claim. That's in writing. Now, he did not make one mention of, oh, by the way, this man's not my employee. He's the employee of an independent contractor. He said, I want this claim covered. Further, the state of Tennessee found out that this man was operating a business without workers' comp insurance, and there was a state audit. And this is hugely important because this is all in writing in the documentation before this court in the technical record. In that state audit, Mr. Wilfong was very forthcoming with the state. He told the state, I have 20 or more employees, and therefore I am not immune from workers' comp. I have to have it. Yet in the trial, in this case, in front of the trial court, he tells the trial judge, I had 5 or less employees, and I'm exempt from workers' comp. That is why, in the state audit, he tells the state that Israel Martinez is his direct employee for the years 2020 and 2021. He tells the trial court that Israel is an independent contractor, again, without general contractor's license and without the ability with no business. That is what led the trial court to find that Mr. Wilfong was not credible as to every single material fact at issue in this trial. So what do we do when somebody is supposed to have workers' comp insurance and they don't, and somebody gets severely injured, we sue them under 56406B, and which says I get to sue them in tort, and they can't raise comp defenses. I misspoke. They can't raise common law defenses to the tort action, and they also don't get the benefit of the Comp Act of holding down the damages, which is what the Comp Act does. It provides an inadequate remedy. Now, my client, when he fell, he fell from a height, hit his head, broke his skull, broke his neck, broke all the bones in his face. He was literally bleeding from the ears and almost died. And he did not have the protection of workers' comp. He had $170,000 in medical bills and not one bill was paid. He was out of work for a year. He received no compensation for it. He's got permanent injuries from permanent hearing loss and has not received any compensation at all because Mr. Wilfong failed to protect his employees, which my client was, by having workers' comp insurance. So
Counsel, with regard to the damages award, and it seems like you're pushing on that at least somewhat here with this portion of your argument, you're asking for a specific increase or an increase by at least a certain amount.
Yes, sir.
Let's assume for purposes of argument that you're correct in terms of some of the damage limitation with regard to salary, for example, and you say that they're not limited by the workers' compensation limitation on salary recovery. Isn't it more appropriate to remand rather than this court to set an amount I look at this amount here and I'm trying to figure out how do we get to that determination as an appellate court? And that's assuming you're right on it, but assuming you're right on it, isn't this something that would be more appropriately remanded to the trial court?
Judge, the length of time that has gone by that my client has received no relief whatsoever, we're trying to get this case across the finish line. And it's simple math on the trial judge found that my client was disabled fully for 52 weeks, and that's supported in the record by the doctor's testimony. So that is the length of time that the trial court found is a finding of fact that is presumed correct. However, this is the only place where the trial court got it wrong. She misapplied the law because she discounted the amount of money by the 2/3 of the average weekly wage under the comp scheme. Under the comp scheme, if you're injured on the job and you normally make $300 a week, then you get paid $200 a week until you are at MMI. Okay, so she discounted it by 2/3 of the average weekly wage, which that's giving the defendant the benefit of the Comp Act when he didn't have comp insurance. And the statute itself says you are not to, we're to apply damages as if this chapter had not been enacted.
In terms of what you're asking for us to do, it is simply a matter of taking away the 2/3 reduction and giving him the full benefit of the full salary.
That's it. That's it, Judge. That's it on the 52 weeks. That's also it on the future wage loss for which there is proof in the record. So, but then I do ask in there, and the court has the authority to do this. I've seen this, and I can't cite you a case, but I know that the Court of Appeals has authority to, if there's an error of law, to rectify that error of law. And when it comes to damages. And in this case, my client had significant pain and suffering, but because the trial judge applied the Comp Act as to the damages portion of it, she gave 0 for pain and suffering.
How do we set a pain and suffering amount, though? I mean, that's what I'm at a loss as to how that's an appropriate action by this court.
I understand, and I anticipated that. I anticipated that being the case. So if we need to remand it back to the Circuit Court of Wilson County to set a pain and suffering award, we can do that. As to Your Honor's question as to just what she ruled on in terms of the lost wage, that's just a math issue, and that can be rectified now.
On the pain and suffering, does she say the reason she's not awarding anything for pain and suffering is because, what does she say about that?
She did not specifically say, but because she applied the Comp Act to the 2/3
inference
reduction,
is,
that's my inference.
okay.
Is that she awarded damages based on the comp scheme as opposed to tort damages, which it should have been tort damages because it was a tort case. My time is almost up, but let me just say this. After the defendant took the position, and I don't really know what to do with this, but after the defendant took the position that my client's not an independent contractor, they then take the position of, oh, well, if the court doesn't find that he's an independent contractor, that he's a farm worker. When Mr. Wilfong's own testimony, I called him as my first witness at trial and got the vast majority of what I needed to prove my case. And I think it's on page 12 of the trial training. I mean, early on in his questioning, I had Mr. Wilfong admit that my client did not plant one seed and he didn't harvest one crop. He was not a farm worker.
With regard to the casual employee issue, same question as opposing counsel. What is this court supposed to do if you have a job that is part of it's in the ordinary course of business and part of it's not? I mean, and I'm not saying that's the right way to divide it, but you could divide it here thinking of the work on the restaurant as being not part of, construction work on it not being not part of, and maintenance work around the property as being. So if we've got something we're shoes in both camps here, how is the court supposed to look at that?
Well, Judge, I mean, this is a case of, the employer had control. The worker didn't. The employee came to work every day doing the work that the employer told him to do, and that included work on the HVAC system, that included maintenance work in all the other buildings, and it included work on doing finish work on the restaurant he was building.
There's no authority that you're aware of. I mean, I take this was the point from opposing counsel too, that there's no authority in Tennessee that clearly answers that question for us, right? There's no case out there that says, well, if it's predominantly this or partially this, or that's uncharted waters here, essentially.
He's either an employee or he's not, and he's an employee. All the factors say so. Last thing I'll say, then they throw in agritourism statute as being a way that they're exempt, when my client is not an agritourism participant, and that was testified to by the defendant. So I just don't know what to do when the other side, his own client's testimony derails those arguments, but he continues to advance them on appeal.
Thank you, Mr. Salters.
Thank you.
Mr. Wong, we'll hear from you on rebuttal.
Well, considering I have very little time to rebut a whole bunch of issues, I'd like to start out. Now, the item he mentions about the agritourism, that's a statute involving immunity to lawsuits for negligence during participants who engage in agricultural activities. We're claiming there's an agricultural exemption that's separate from the immunity statute. There's casual employee and then agricultural or farm worker. And the definition of agricultural or farm worker is broader than just planting seeds or harvesting crop. It involves people who also do work, maintenance, or improvements on farm property, which this was farm property. Raul Martinez was helping finish out a building, so that is an improvement on farm property.
Counsel, under that understanding, if somebody's building a house on a farm property, rural property more than 15 acres or whatever the statutory division is, are they engaged in farm labor? So I buy a rural property and I have somebody build a house. Are they engaged in farm labor on my property?
I cited the statutes on it, and I can only just read the statutes literally as it's written. It says farm property includes any, I don't have the exact quote in front of me right now, but any buildings, structures, or equipment that is used in the commercial production of farm or crops. So in theory, by definition, yes, any items and equipment that's on farm property.
It sounds like to me then a restaurant would not be farm property because that's not used for the production of crops.
And here's the rub. Agritourism has just become a thing in Tennessee for maybe the last 20 or 30 years, and they've passed and progressed laws involving agritourism. The statutes actually now include agritourism activities, recreational entertainment activities conducted on a farm property that's secondary or coexisting with the production of crops. That is now considered a area of agriculture. It's technically, agritourism is now a part of agriculture. So that's one of the items that Mr. Wilfong does. He offers hay rides. He had 8 acres of grapevine plantings that he did. He grew corn, banana plants.
What's the timing of the two statutory provisions then? I mean, you said in recent years agribusiness has become a thing. I mean, the statute didn't change its meaning because of agritourism becoming a thing.
It actually did, Your Honor. There's This case is not directly on point. Shore versus Maple Lane Farm, Knoxville case, decided 2012. That involved a nuisance lawsuit where a farm was hosting concerts, helicopter rides, and all that stuff, a pumpkin patch, and the neighbors filed a nuisance suit because it was causing all kinds of sounds and disturbances at all hours of night. And the defendants, the farm owners, relied on the agricultural statutes that says no nuisance actions or causes of action could apply to agricultural land if it was a normal part of farming activities. And the court in Shore decided that doing things pertinent to farming, such as offering some concerts or events, was ancillary to farming operations. So therefore, that counted as agritourism, which is an exemption that falls under the agricultural exemptions, where zoning laws don't apply to agricultural property. Nuisance cases can't be pursued against noxious odors and sounds coming from farm property. So strangely enough, that was a 2012 case, and I think it was maybe the first of its kind to decide that agrotourism was a subset of agriculture for purposes of Tennessee statute. So that's within the last 15 years. So it's not an old law, but it's not exactly recently new, the agritourism statutes. So we would say that even though Mr. Martinez did not plant seeds or harvest crops, Mr. Wilfong did engage in agrotourism activities along with his event hosting, which implied that Mr. Martinez's job on the farm was in assistance to the agrotourism activities that were going on the place. Also, a few other points. The appellant, David's group, did not directly hire Raul Martinez. Raul Martinez was brought in by his brother, Israel Martinez, when the David's group needed some extra help doing construction. They told
Did Israel Martinez hire him?
Israel Martinez just showed up with a whole group of people after the David's group told Israel Martinez that they needed help doing construction.
So he had the authority to hire people?
Mr. Wilfong, who's the owner, 100% owner of David's group, didn't directly hire Mr. Martinez. He was brought on through Israel Martinez, along with a bunch of other workers. There was maybe 6 or 8 other people at various times that Israel just brought with him. So that kind of made confusion. And also, transformation of property is not a line of business. It has to be something that's understandable. I would say the business classification codes that the IRS uses, something that falls under there. You're a physician, a doctor, you do construction, you do events hosting, you do convenience store. I don't think transformation is a business category, which is what the judge kind of considered Mr. Wilfong's business to be.
All right, Mr. Wong, you're out of time.
I'm sorry.
Thanks. Yeah. Thank counsel for both sides. The case is submitted. If you will call our next case, please.